Good morning. I'm Councilmember Jim Gray. I'm chairperson of the Committee on Human Services. The time is 11:10 on Friday, January the 13th. We're all going to be very careful today. Think of our grandmothers and what our grandmothers told us about this date. But here we are on Friday, January 13th, 2012. We're in the Council Chamber, room 500 of the historic John A. Wilson Building, located at 1350 Pennsylvania Avenue Northwest, to conduct a public hearing on Bill 19-466, the Child Abuse Prevention and Treatment Amendment Act of 2011. The Child Abuse Prevention and Treatment Act state grant program provides funding to states to improve child protective services systems. Grants are based on an initial allocation of $50,000 per state, with additional funds distributed in proportion to the state's population of children under the age of 18. So right off the bat, there's very little money involved in this. As you'll see, I think we have a total budget of $86,000, which is not very much. But this federal program supports states in a variety of ways, focused on improving prevention, assessment, investigation, prosecution, and treatment activities. CFSA, the Child and Family Services Agency, its core service for this funding is the support of intake and investigation of child abuse and neglect allegations. And of course, this comprises a very tiny amount in that CFSA budget, only $55,000. The district uses the remaining portion, which is about $30,000, to support the activities of the district citizen review panel. I don't know how far that money goes either. Anyway, the panel is comprised of citizens who meet regularly to examine CFSA policies, procedures, and practices, and to periodically evaluate the extent the agency is effectively discharging its child protection responsibilities under CAPTA, which is the name of the program. On December the 20th, 2010, President Obama signed into public law a 5-year reauthorization of the Child Abuse Prevention and Treatment Act. The purpose of that bill, this bill, is to amend the district's Prevention of Child Abuse and Neglect Act of 1977 to conform the requirements of the Federal Child Abuse Treatment Act to those that we have locally. And we already have passed an emergency and a temporary on this. The emergency has expired. We're now under the temporary law. The temporary law is identical to the bill that is before us today. So the legislation will confirm the following changes. One, not require the Child and Family Services Agency to make reasonable efforts to reunify or preserve the family if a parent has committed certain crimes against a child. Excuse me. Let me just get this off. I forgot to turn it off. So the first part of this legislation would not require the Child and Family Services Agency to make reasonable efforts to reunify or preserve the family if a parent has committed certain crimes against a child, or if the parent must register with a sex offender registry. Now, we don't have that requirement of reunification in the District of Columbia, and it's a little difficult to follow this, but this would be a provision that would not require CFSA to make reasonable efforts to do so. So we want to look at that, of course. It would also require healthcare professionals to notify CFSA when a child under 12 months of age is diagnosed with a fetal alcohol syndrome disorder, FASD. And finally, it will expand and clarify the definition of neglect to include an infant that has been diagnosed with fetal alcohol spectrum disorder. As I mentioned, on September the 20th, I moved this same bill on an emergency and temporary basis. That was in order to keep us in compliance. And today we're holding a hearing on the permanent version of the law, which is identical to the temporary. So we'll begin with our public witnesses, and I believe we have 2 public witnesses. Judith Sandalow, who is the Executive Director of the Children's Law Center. Kevin Emanuel Quick, Survivors Network of Those Abused by Priests. Mr. Quick, are you here? Mr. Quick is not here, so we have Ms. Sandalow.
Hey, Mr. Graham, and Happy New Year.
Happy New Year to you.
This may be the shortest hearing I've ever participated in.
It may be.
I will try not to lengthen it.
Sometimes very short hearings become very long before you know it.
There you go. As you know, I'm Judith Sandalow, Executive Director of the Children's Law Center, and I'm a resident of the district and a proud resident of Ward 1. I'm testifying on behalf of Children's Law Center, which is the largest legal services organization in the District of Columbia, and the only one devoted to a full spectrum of children's legal services. As you know, every year we represent more than 1,200 low-income children and families, particularly children in foster care, children with special health and education needs. The majority of our clients are children in foster care or their caretakers, so obviously this bill matters to us. And I want to start by commending CFSA and you and your staff for following federal law, catching that we needed to do this. And even though it is a small amount of money, every dollar matters at this point, so we think it's terrific. And a really nice move forward for the city that we're paying attention and catching these things. And we support the bill. We would ask for one small technical change. Right now, the language, as you described very clearly, amends the reasonable efforts part of the statute. Our suggestion that that just be moved to a separate section of the statute. The reason for that is folks who are putting law into practice on a day-to-day basis have a tendency to read simply, and I don't mean that as a disparagement, but if you're in the trenches every day, you read the law, it says you don't have to make reasonable efforts. It's kind of a cookie, it leads towards a cookie-cutter approach to families, and if we move it, it seems like a small act, it forces all of us to actually think about kids and parents as individuals, with also allowing us to be in compliance with CAPTA and giving us the flexibility to do what's right for a child. And then I just want to close by saying that we are thrilled. It's the first time I've had a chance to testify since Ms. Donald was announced as the director of CFSA. We're delighted she's here. We are looking forward to working with her and her newly constituted staff to make changes in the district. Thanks.
Thank you very much, Ms. Sandalow. Did we get testimony submitted by the other witness? We do have testimony. Okay. I think, you know, this is a nuanced issue.
It is.
And I think your testimony seems to suggest adding a further nuance, which is that you keep the identical language, but you just put it somewhere else.
Lawyers can add nuance to nuance.
They can. And being a lawyer, I'm well aware of that.
Yes.
But I'm not sure that, well, I want to make sure that we don't lose sight of what's really involved here. And yes, we have a direction from the federal government, as does every other state in the union.
Yes.
That this jurisdiction not require reasonable efforts to reunify or preserve the family if the parent must register with a sex offender registry. So it does not say, you know, under all circumstances, there can be no efforts at reunification in that case. It does not say that. It says that we are not to require a reunification effort. And so since our law does not require a reunification effort.
Right.
Am I correct?
Yes.
Then the most important nuance is the fact that we're already in compliance with this.
I think that's probably right.
And we can probably enact this, and we want to hear from the General Counsel of CFSA who is testifying today. But this probably does nothing to disturb what is our current law.
Technically, I think that is absolutely right. And so the point I am trying to make is the difference between what this conversation and then what lawyers, judges, and social workers will use, how it will be used, I think is a little bit different. And so our experience representing, you know, more than 500 kids every year is that where something is in the statute either makes it seem, okay, we don't need to exercise discretion, we do. And if it's in the reasonable effort section, it's our experience that the agency, judges, just don't make reasonable efforts. I mean, if you're allowed not to, they don't make reasonable efforts. And we're just trying to move it to a part of the statute which will make all of us stop and think a little bit more. And technically, there isn't a difference, though.
You know, and I have great respect number one, the wonderful working organization. I really do think that everything possible to treat individuals as individuals.
Yes.
And recognize that there are many different varieties of situations which need to be dealt with. And I have a lot of respect for your skill as a lawyer as well. But the fact of the matter is that you're moving exactly the same language, so there's no change. There's not even a change in a comma. It's still going to be in the legislation. So
yes.
I don't know whether there might be some mischief in that. I don't know. Maybe there isn't.
I stake my reputation on not being sneaky. So I intend no mischief. And I actually was just asking Mr. Sims in advance whether he saw a downside, which I'm sure he can address, because if there was one, we didn't know what it was. On that I can promise. We're not trying anything
No.
untoward.
I'm not suggesting that you are doing anything sneaky. I'm just suggesting sometimes there's unintended mischiefs. Mischievous things happen. And I don't know, and I think the way you put it initially is absolutely correct. We're building nuance on nuance on nuance.
Yes.
And the fact of the matter is, when I saw this legislation, when I introduced the emergency and temporary on behalf of the mayor, I saw this as really not disturbing at all our current law. Mm-hmm. And so I wasn't really troubled by it in any way. And that's kind of still my opinion. Of course, I'm not, we don't have our other public witness here today, but I have a feeling what he would testify to here. And there is a grave public concern about people who are sex offenders and are convicted sex offenders.
As there ought to be.
And so I don't want to send any kind of message which says that the District of Columbia is going to be in any way, nuanced or not, more tolerant of the situation in terms of reuniting that person with their infant children. You know what I'm saying?
I do.
It's a very sensitive issue, and I suspect the best way to handle this is to say that this really doesn't impact what we do, because we don't have any requirement of a reasonable effort to reunify in this circumstance. Right?
We do not have a requirement.
We don't have a legal requirement.
Right.
CFSA is not bound to attempt to reunify, and the law says that we don't want a requirement of a reasonable effort. And since we don't have that requirement of a reasonable effort,
there's no requirement to reunify. And the CAPTA statute says we have to make sure that there is no requirement to reunify, which there isn't. We just want to move it out of the reasonable efforts piece, which is true.
Well, let's find out what our CFSA experts advise us in this. But wonderful. I thank you very much for your testimony. Thank you, Ms. Sandalow. And now we're going to go to our agency witness, who's Mr. Lionel C. Sims, Jr., who's General Counsel of the Child and Family Services Agency. Thank you.